Okay, I believe everybody has the material. We'll call the meeting to order, and I will open us up with a word of prayer myself. What say again, Gail? Let's pray together. Father, for the privilege of serving you and the privilege of serving the citizens of the state of Georgia, we thank you. We pray for wisdom that we would do it well. In Jesus' name, amen. Okay, thank you for coming. Today we are hearing 4 bills. 3 were on the agenda: House Bill 883, House Bill 903, and House Bill 915. We will be hearing House Bill 982, which is a department bill. We'll be hearing it last if you want to take a look at it prior to. Calling today is a hearing only. We are hearing the bills and we are not voting. So that being said, we have an hour and a half, which we have run about 15 minutes, so that gives us, you know, what, how many 4 bills? 20 minutes, you know, something. We're going to try to make 15 to 20 minutes per bill. There's a sign-in sheet down here if anybody wants to comment or speak on the bill, and we'll accommodate everybody we can in the interest of time. But again, we're only having a hearing. That being said, let's start ladies first. House Bill 903. Representative Jones, are you ready? Then you right up there, and you can proceed.
Thank you, Chairman, members of the committee. I'm presenting to you House Bill 903 today. This is what has been called around the nation zombie foreclosures, and it is the last leg of our mortgage crisis that our country began facing in 2007. And it's really simple. People lost their homes, could not work out whatever issues with the bank, and 4 or 5 years later, they are getting notices from the tax assessor's office, they're getting notices from code enforcement and from the cities, and from their homeowners associations saying, you still owe us and you have to pay. Many of these folks are being dragged into court, and they are required to pay fines because the judges, the solicitors, and the other folks there have no other option other than hold the last person on the deed responsible for those fines. I have with me today a number of people who I would like to speak to the bill, and they are representatives from both the solicitor and the public defender's office in the city of Atlanta. And they'll be able to tell you that this is happening for thousands and thousands of Georgians that are left. What this bill is an enforcement bill. As you already know, in Georgia, the banks are required to file a deed under power within 90 days. And many of them are not doing it. Some simply because they are too busy, others because they know that these properties are just not worth what they are, what they once were, and not worth taking them back. What we are seeing across the country, and I think we have an article that we've handed out to members of the committee, in the Midwest particularly, they're noticing that this is coming from the larger banks. Our small community banks that knows the people who they're lending to, they're not having these problems. But Citi Mortgage, Bank of America, and a few others have been listed as some of the most egregious offenders of not filing the deed under power. This measure is a bipartisan measure because it fairly protects individuals who owned property at one time, couldn't afford it, and lost it, but at the same time, the only thing the banks have to do to not suffer any penalties, any problems, is follow what's already Georgia law. File the deed under power within 90 days. And I know you all know this, but to file a deed, you simply go to your superior court clerk, pay $10 to $25, and it's done. It's a one-page document that there is zero reason or excuse why the bank simply couldn't do it. The bill has 3 parts. It's very simple. The first part requires notice. What we've seen is that right now the banks must give a 10-day notice to say, we're going to foreclose on your property. For one reason or another, the banks decide not to foreclose that month, and they come back the next month and they send you another letter and another letter. Well, what they're going to tell you from the public defender's office is people pack up and move out, and they're never notified that the house was never properly foreclosed on. So what the notice requirement is that after filing the deed or after foreclosing on the property, the banks must notify the person that everything has been completed according to Georgia law and you must get out. The second thing that it does is it allows the homeowner to stay in the home until such time that $10 deed is filed. Well, I know that concerns people. We don't want folks unjustly staying in their home that they're not paying for. But these folks should be able to protect the homes from the windows being damaged, from the code enforcement fees, from the taxes, by being able to protect the property in case in the future the banks decide they're never going to file this deed. We also believe that it will encourage the banks to file those deeds within the 90 days as required if they know they can do nothing to get the people out by Georgia law. The final thing that the bill does is create a cause of action. So for the cities, it's not worth going after Ms. Johnson for that $1,000 to repair the property. But if they know that Citibank or Bank of America or any of these other big investors that buy up a lot of properties have hundreds and hundreds of these, they can go after that large bank or investor for the cost that it takes to board, prepare, and protect these properties. These houses, these zombie homes, are causing blight in our neighborhoods. It's causing dangerous activity to occur in our neighborhoods, and we need our country to turn around. And so it would behoove us as Georgians to finalize the protections we created after the mortgage crisis and ensure that we put this bill forward to protect them. If we don't do it, we'll be telling the big banks, it's okay, you don't have to follow the law, and you don't have to file a deed. We'll be telling our courts, yes, we know that you know who the real owner is, but you still have to go after innocent Miss Johnson for the money. We'll be telling our cities, we don't care. You just have to figure out a way to pay for all these blighted houses. And we're going to be telling our community members, we don't care about these abandoned homes and your property, and we're not going to make anybody be responsible. So I ask for your favorable support for the bill. I don't know if you want to take questions now or allow the other folks I have with me to speak, Chairman.
I'll allow you to take questions if there are any. I don't know who was first, so I'm going to just down here. Oh, I have to do it with the mouse. Is that Representative Strickland, I believe?
Representative, our current dispossessory procedure, doesn't that address someone's right to remain in a home? And isn't that the way that the banks actually get somebody out of a house? Is my question, if I'm correct on that, why is the current procedure we have for dispossessory not sufficient to address this issue?
It's a great question, Representative Strickland, for two reasons. One, because many people never get to the dispossessory process. Simply receiving that letter and believing that their home has been foreclosed with no other notice makes them pack up and leave, and they are still the responsible owner unbeknownst to them. The second reason is because the dispossessory process does not require a stamp filed deed under power. So what experts have told me in my research of the bill is that they go down to Fulton County dispossessory, someone from the bank says, oh yeah, we have a deed under power, but it's not stamp filed, it's never been recorded. And that is sufficient, because there's no other requirement at the dispossessory level, that is sufficient that allows the judge to require the folks to move out. So I agree with you. We need to strengthen the dispossessory rules to make sure that the banks are providing proper filed notice of the deeds under power.
Yeah, I mean,
If I may follow up. And I wasn't implying that we need to make the dispossessory process stricter at all. It's just a question because, I mean, correct me if I'm wrong, but there's basically a preponderance standard, a civil standard in a dispossessory. So if someone wants to argue that a bank does not have legal rights to own that property, they could use a defense in the sense that let's just not stand and then present evidence to try to refute the fact the bank has a right to that property. Is that not true now, the way it's set up?
Well, so here's the thing. The banks technically have a right to that property. The person hasn't paid their mortgage according to their agreement. And so what the dispossessory court is going to do is say, well, do you have proof that you paid? If you don't have proof that you paid, according to your agreement, you have to get out. But that does not address whether or not a deed under power is filed to ensure those people are not held responsible for the back taxes and everything else later. So I guess what I'm saying is this is two separate issues. Making the people get out is one, but then continuing to hold them responsible after you've kicked them out is something completely separate. Did I answer your question?
Yes.
A little bit.
Thank you.
Representative Smith, you have a question?
Thank you, Mr. Chairman. Representative Jones, just to clarify this for us, especially for me. Did this problem not start about 6 years ago when the real estate boom went bust? And it was said that it would take about 5 to 7 years for all of the fiscal chickens to come home to roost, and we would see the impact of how this would affect all of the people that would sufficiently lose their homes, and the fact that it would actually just become fiscal as opposed to something that has something to do with real estate, but all about money.
That's correct. And what one of my speakers have here today, she'll explain to you that she's been doing these types of cases in the city of Atlanta since 2005, but it wasn't until 2007 that she continuously saw people coming into court daily with these same issues. And right now, Georgia ranks number 7 for the number of houses in the entire United States that have been foreclosed on, but no deed has been filed, and they're just out in limbo. So you're right.
Representative Frazier.
Thank you, Mr. Chairman. Thank you, Representative Jones, for this bill. I was unfortunate to have exactly an entire neighborhood that went bankrupt 7 years ago. An entire neighborhood that was less than 1 year old. So I watched beautiful $200,000 homes sit and deteriorate. Now my question to you is this: how does these notices get to the homeowners if they have left a home and a year later or 6 months later they get these delinquent fees in the mail? And also, where does the line be drawn for criminal for the fact that they don't pay the bills? Are we now incarcerating them, or what are we doing to help them get these fees paid? Or else this will happen. I don't know the law, and I know you probably do. So what is the current law?
So each of those laws are handled by each municipality that decides. But yes, some of them can include jail time for them not paying the fines and fees that they accrue after they've moved out of the house. And so that it makes it really dangerous for the folks who formerly lived there. The notice, however, would be required within a certain amount of time after the actual foreclosure or deed under power is filed. And they would need to send it to the person at the address that they had. Now, most of us know that if someone moves out of a house, you usually have your information for at least a year. Many of us who, after you move out of house, go back and check the mail initially before someone else moves in. So we believe that if the notice is sent within a sufficient amount of time, the folks will have an opportunity to know that everything has been completed. But understand this: the purpose of the notice is to say everything has been done legitimately and you have no argument, you have to go out. If the people are already moved, it would make zero difference. What we're trying to solve with that is that what will happen is the banks will send a notice month after month, but never actually foreclose, and people are thinking they need to leave when they really don't.
Mr. Chairman, follow up. So you're saying that we now want this legislation to require banks to issue that deed under power within the 90 days. That's what this legislation will do.
No, current Georgia law already requires that. What this legislation would do will help to enforce the banks to do that.
Okay, so what is the time frame that a bank will do a foreclosure? Does it take a year instead of how long?
You can finish a foreclosure in 30 days in Georgia or less. And some of you guys on the committee may know even better than I, but you can finish a foreclosure rather quickly here in Georgia, not a year at all.
So why are the banks prolonging this?
So I've heard two reasons in speaking with the banks. One, they just said they have too many houses and they just have not caught up. 4 years later, however, that excuse does not remain to be valid. So what we are seeing and what you'll hear from our speakers, that a lot of these houses are in the poor neighborhoods. So imagine this: a neighborhood where the property value has plummeted since the mortgage crisis, and then since then the house has been vandalized with over $20,000 worth of copper stolen, all the windows broken, the grass grown up to the sky. It would cost a bank or an investor upwards of $20,000, $30,000, $40,000 to fix the house, not even to mention the back owed taxes that should have been paid every year, any liens put on the property for other things not done with the house. So for a bank, if a house is not going to sell and make you a profit, why file the deed and make yourself responsible for something that you really didn't want in the first place?
you repeating banks, does your bill just address banks?
I believe that it's anyone who files a deed under power, and I want to pull up the exact language, anyone who files a deed under power. So if you are an investor, it counts for you. And the reason why I continuously say banks is because that's what we've seen most egregiously is the banks, but it will apply equally to investors as well.
Under what circumstances did you say an individual could be jailed for not paying, did I understand you to say condominium type fees or?
These would be
or neighborhood, I mean, what do you, not condominium fees, but, yeah, HOAs.
So not for the HOA fees, but I have here with me one of the public defenders from the City of Atlanta, and so the code enforcement violations. What brought this issue to my light was a client coming in who had over $1,000 worth of code violations. If you don't pay for your code violations, you can be jailed under City of Atlanta law and many other municipality laws. Now, of course, that rarely happens, but would we ever want to put someone's liberty in jeopardy because they can't afford to repair a house that they didn't own anymore?
Okay. Are there any further questions for Representative Jones from the committee? Where's the list at? So I know who to call first. Yeah. Thank you. Is your witness, I don't have anybody from the city of.
No, I didn't sign them up. I'm sorry, Chairman. I didn't know if they would come up with me or separate, but I do have 3 people that I would like to speak to the bill.
Okay, this is 903. Yeah. All right, bring your witness, and we won't give time for everybody else on 903, but limit to 5 minutes.
Thank
Tops,
you.
Please.
Thank you.
Thank you.
Miss Erica Smith, can you come up?
Identify yourself and who you're with, if you will, for the committee.
Okay. Good afternoon. My name is Erica Smith. I'm Deputy Solicitor in the Solicitor's Office with the City of Atlanta. I prosecute the housing code violations, which covers any type of violation that you receive for open and vacant property that is vacant, which are the properties that are left vacant by these people that are moving. I get on a daily basis. From 2005, I prosecuted thousands of cases where individuals thought the house was foreclosed upon. However, a deed was never filed. So in the prosecution process, we go to the last known owner. And so when we go to the Fulton County records to find out who was the last known owner, it is John Doe. It's not the bank. When John Doe got a letter 5 years ago that XYZ Bank had foreclosed on the property. And Representative Jones is correct. In the City of Atlanta Municipal Court, you can be fined up to $1,000 per day for the violation, or you can be jailed up to 6 months for the violation if you can't pay your fees or fines, or if we assess jail time for it. This whole process of the zombie foreclosures has caused significant blight within the City of Atlanta, especially within certain areas. If you're familiar with English Avenue, Vine City, Pittsburgh, I see it on a daily basis, and it is a problem because we don't have the protection to go to the banks who has the deeper pockets or the investor who has foreclosed on the property. We have to go to the last known owner who may be suffering and indigent, and most of the time those people are represented by the Public Defender's Office, and John Tappy is here on behalf of the Public Defender's Office.
Okay, thank you. Well, I'm sorry. I think we've, you very eloquent in describing exactly the process. At this point, I'm going to recognize Mr. Culbertson. If you'll identify yourself to the committee and who you represent, you're at the first of the list. We're going to try to be fair. We're running out of time on the hearing of the bill for those for and against.
Thank you, Mr. Chairman. Members of the committee, it's a pleasure for me to be here today and speak on behalf of the Georgia Credit Unions. We have had the opportunity to talk to Representative Jones a little bit earlier. We are opposed to this legislation for a couple of reasons. Number one, just for historical background, credit unions, even during the credit crunches during the past 5 years, have continued to make conservative and really conventional type of real estate loans throughout this period. And really, as a service to their members, they've continued to do that. During this period of time, we've seen more and more, I guess, resulting regulations and types of things, both at the federal and state level, that have been imposed on all financial institutions, regardless of their size, including credit unions that really serve their members. Because of that, the cost of compliance for more and more of our credit unions is the third largest expense that they have on their balance sheet today, behind only personnel and facilities. So as we add more and more layers of compliance rules and regulations, it gets even more difficult for credit unions to continue to offer these important services to their members. As a matter of fact, I talked to one credit union just last week that because of some of the new regulations imposed on them by the CFPB at the federal level, they have decided to suspend making any kinds of home equity loans for the near future. These are the kinds of results that we see because of these new rules and regulations. The second thing that happens on this is what happens in the secondary market. Anytime Georgia takes something that's outside the normal standards that we see on a national basis, that makes it extremely difficult for us to continue to participate in the secondary market, which is important for credit unions who have any types of liquidity problems that need to sell their real estate mortgages on the secondary market. If we have things that are outside the normal, the secondary market demand starts to dry up, and our ability to do that is really taken away from us. The last thing that I'd like to make a point of is keeping folks in those homes during this foreclosure process. Credit unions, I can speak for directly. We do everything we can to avoid a foreclosure and putting people out of their homes. I can absolutely testify to that 100%. By the time it goes through the foreclosure process, many times there is a kind of an air of almost revenge from some of the folks that are in the homes now. We have seen instances where during the foreclosure process there's been continued damage done to the homes on purpose, out of revenge. At the very least, the normal maintenance and repairs are not kept up to date. For us, when we go through the foreclosure process, we finally get possession of the home. We do a lot of repairs and rehabilitation to the house before we sell it, because we want to maximize the amount that we're going to get back for the home and minimize the amount of losses that we're going to have from the loan itself. So for those reasons, I really, unfortunately, stand as against this legislation and encourage you not to adopt this. So if there's any questions?
No, sir, we don't have time for questions, but thank you for that.
Okay,
thank you. Mr. Barber? If you'll just identify yourself for the committee and who you're with, and give us a very brief, were you for the bill, and 30-second explanation.
Yes, sir. John Barber, the Georgia Association of Realtors. Thank you for your time. I'd like to make my comments very brief, speaking directly to lines 40 to 42 of the bill. We have some serious concerns from the Realtor Association about this language, because it would allow the person that has been foreclosed upon to remain in the property after a foreclosure sale. Now, you could have instances where you have an investor that has purchased the foreclosure at the foreclosure sale from the bank. Now, that investor may want to immediately begin to work on that property to fix it up to get it back on the market so they can recoup their investment. This language in the bill, I think, is not intended specifically for those types of investors, but it would be all-encompassing. So I'd like to give some serious consideration to the impact that this language would have by restricting a future purchaser's right to have access to their property and allowing the previous occupant to remain in the property, and from this as in the current language, until the deed has been recorded, which could be up to 6 months or longer. So thank you for your time.
Thank you. Ms. Johnson, Georgia Watch. Oh, I'm sorry. Okay, you're right. Okay, then we have, was there somebody else who wanted to speak very briefly? Oh, I see. Mr. LaFranco? Yes, sir. Okay, all right. Tell us who you are and who you represent.
Hi, Mr. Chairman. Sorry. My name is Scott LaFranco, members of the committee. I'm a foreclosure attorney. I work for McCall Reamer. Y'all probably heard of us. We do the majority of the foreclosures in the state. I wanted to sort of address some of the things that were discussed in the presentation of the bill. First of all, the actual foreclosure process is a 30-day process. That's when you send notice. The notice of the foreclosure sale has to run for 30 days, 4 weeks is what the statute says. However, on average, it's generally a 7th-month process. And during that time, that's when the borrowers are being reviewed for loss mitigation options, your workouts, short sales, etc., things of that nature. I'll just sort of summarize. Our position is that this bill doesn't really help the borrowers under existing practices in the existing case law. With respect to the first component of the bill, sending a notice or completion of the withdrawal of the foreclosure sale within 14 days, the borrowers are actually allowed to call. The current practice is they call in and confirm, and we send them written notice saying, yes, the foreclosure sale has been postponed to X date, or the other issues, you send them a letter saying that yes, the foreclosure sale has been completed. The other aspect of it is that if they are in the property, they will, by virtue of foreclosure sale, it creates a tenancy at sufferance, where the lender, the foreclosing entity, is the landlord essentially, and the foreclosed borrower is a tenant. To sever that tenancy, they need to send a written notice of demand. So that will be their notice of completion of the foreclosure sale. As respect to the second component of the bill, most of the GSEs, if that deed isn't recorded within 90 days, they're imposing penalties and curtailments on the servicers for not, they're self-imposing fines when they don't meet those recording deadlines. Making the foreclosing entity responsible for all fees and fines incurred upon the property upon giving notice of the foreclosure sale. Well, when you foreclose, as of that date, you're responsible for those fees as of the date of the foreclosure sale. Now, there's certain things that don't get foreclosed, like taxes, things of that nature. So that would be on the borrower, the foreclosed borrower, things that existed. But certain liens, most of the liens get wiped out by foreclosure, which is why why we go through that process in the state. With respect to the issue of zombie foreclosures,
very quickly, I've got to
yes, sir.
go some other business.
It's not just a matter of keeping records on their books. There are issues that cause delays in foreclosures. A lot of them can be a litigious borrower, bankruptcy filing by a borrower delays foreclosure sales. There are issues that could delay a foreclosure. And again, we are opposed to this bill just because it doesn't provide any protection that they're not already getting.
Okay, thank you. Ms. Jones, thank you for presenting your bill and those witnesses and questions. Let's see. Representative Clark, are you ready? Okay, we'll proceed. LC 335508S. This is a substitute to House Bill 915, I believe what everybody's got in their folder.
Thank you, Mr. Chairman. Yes, you said LC 335539S.
I've got 08. Well, I've got both. Okay, all right, okay. Yes, I do. You should have both. What are we doing with two?
There was a slight change made in the latest substitute to working with Equifax.
So what you're presenting is 5539S?
5539S, correct.
All right.
Substitute for HB 915.
Okay, all right. Everybody got it? All right, go ahead.
We good? All right, thank you, Mr. Chairman. This bill was brought to my attention by Bradley Robertson, a constituent and a teacher who, after listening to Clark Howard on the radio, became concerned over the alarming rate of child identity theft. After he brought this to my attention, I began researching and met with Clark Howard. Was alarmed to learn that a minor is 35% more likely to be a victim of identity theft. In fact, 1 in 10 children by the age of 18 discover their identity has been compromised. 15% of them are under the age of 5. Thieves use the Social Security number of a child to open credit cards, secure loans, etc. One child had 6 people linked to their Social Security number. The largest case of fraud that I'm aware of is $1.5 million against a teenager. This bill mirrors the adult credit freeze that passed Georgia over 10 years ago and that swept across the states. Clark Howard had intended to be with me this afternoon, but had travel plans that got in the way. I don't want to take up too much of your time. I understand that you're running already running long, but this bill is really, again, mirrors the adult credit freeze bill and just gives a parent or guardian the ability, the right to contact a consumer credit reporting agency and request that, one, they do a background check to ensure whether that child has a record, either linked to their Social Security number or their name, and then request that the credit agency lock their child or the child's credit. The credit agency is able to charge a nominal fee up to $10 for providing that service. And I think with that, this has been passed already by 7 states already. We would be the 8th to pass this bill. And I think we have a few people registered to speak to this bill. So would you like me to take questions?
No, do you take questions from the committee if there are any? Are there any questions for Representative Clark from the committee? No questions? Okay. Yes, sir.
Thank you, Mr. Chairman.
Well, then at that time, now I'll recognize Ms. Johnson with Georgia Watch to speak on 915. Excuse me.
Thank you, Mr. Chairman and committee. My name is Carla Johnson, and I'm with Georgia Watch. Some of you may know that Georgia Watch is a statewide advocacy organization. Clark Howard actually serves on our board, so I guess I can be in some representation of Clark. We are in support of this bill for obvious reasons. House Bill 915 particularly is of interest to Georgia Watch because that's what we do. We watch out for consumers. In my job as a consumer outreach director, I work to make sure that people understand their credit. I work to help people understand how to protect their identities. Identity theft is one of our most important and sought after workshops that we provide. During our workshops, we talk about how identity theft is the fastest growing crime in America. And right here in the state of Georgia, we're ranked number 2, and we've held that spot since 2007. Speaking of 2007, Representative Clark mentioned that we created a credit freeze for adults. We think that same credit freeze should apply to our most vulnerable consumers and our most vulnerable constituents, which are our children. A few other important points I want to point out. In my opinion, identity theft, child identity theft, is one of the worst forms of identity theft because it goes unchecked and unnoticed for so many years. As Representative Clark also pointed out, a child is more likely to get their identity stolen. 1 in 10 children have their identity stolen. So if we were looking at this audience here today, it's about 20 of us here, 2 of us would have had our identity stolen. I don't think anybody would want to sign their children up to have their identity stolen. The final point that I would like to put out is crooks seek the most vulnerable amongst us, and we know that to be our children. We need to do what we can to protect their financial futures. I think our 1 and 2 year olds 18 years from now will thank us and your wherewithal and your vision and your leadership for having passed this legislation. If you have any questions for me, I'm happy to take those. If not, thank you for your time this afternoon.
Thank you, Ms. Johnson. And Representative Clark. Nobody else has signed up to speak on the bill. So that's great. Representative Clark, Georgia Watch. It don't seem like we're in the same building with the gun debate. Yes, absolutely. Come back. Yeah, come on back up.
I was remiss in not mentioning that Equifax has been a great partner in working with me on this bill. I appreciate their doing that in great spirit.
Okay, good. All right then. Well, that sounded good. Okay, well, it looks like we've got another stab at bipartisan efforts here with House Bill 883. Representative Strickland, along with Representative Earhart, Williamson, Douglas, and Flood. This must be a good one.
It is, Mr. Chairman. I can stop right there if you want.
No, you go right ahead. Proceed.
I bring to you House Bill 883. In 2012, before I was here, you guys passed the Georgia Merchant Acquirer Limited Purpose Bank Act. And I've been practicing all day to make sure I can say that in one mouthful without stuttering. But it was a great bill. What the bill actually did, the way it was explained to me is, for example, when I go to the dry cleaner and I present my credit card to the dry cleaner, there actually is a bank in the middle that actually delivers my funds to the dry cleaner and then gets money from me